second time he's come to one of these meetings, the meetings where there can't be more than people.
These are the leaders of the city.
Yeah, it's good. I meant to send out a text with a link to Marlon Bunda.
But he's still nice at them, so it's like he's gonna do more than he might do.
Michelle?
I better be careful what I say because she's an idiot.
Morning, everybody.
Get control.
We're gonna get started in a couple of minutes. We'll let some more folks get on. If everybody could stay on mute unless you have a particular question as we go along. A lot of you did submit questions in advance, which was very helpful. We will cover topics that reflect on as many of those questions as possible during the session. And my commitment to everybody is that if you submitted a question, you will get it answered, even if we do it offline. Or I will send you to somebody who can answer it, because some of the questions are more of a general counsel nature, which is not our bailiwick. But if you don't already have a general counsel, I'll get you connected with a good one to answer your general counsel question. Let's wait another minute for a few more people to get on. One of the things you'll see today between me and my partners is the various levels of lawyer dress. So my partner, John Lamole, has got the full lawyer garb, including his suit. I got the suitless.
And Alan, I got jeans on.
All right, and my partner, Salvador Scro, is reflecting our site inspection outfit. So we wanted you to see us in all those capacities.
Yes, I told myself today was shirt and tie day, and when I left, I knew I was forgetting something.
All right, let's get started. So one minute on who we are so that you know who you're listening to today. We are Tannenbaum, Scro, Lamole, and Kleinberg. We are construction lawyers, and the majority of our practices is within the community association field. So we are a boutique firm that serves a community association industry from Central Florida, across the Tampa Bay and down to Naples. And we support groups coming through turnover. We analyze and pursue turnover claims where it's appropriate. We get involved in consulting on major repair projects, and we clean up or support you in cleaning up repair projects that don't go well. That's basically our major fields of endeavor. So we don't do general counsel work. In fact, a lot of the general counsel refer us turnover and construction issues where they would prefer to stay with their general counsel representation. They refer that work over to us. So we have some great relationships with general counsel. We know who the really good ones are if anyone ever wants to ask us that question and you're not presently represented. So the issue that we're going to cover today is resolving claims arising from new construction and major repair projects. which is probably an 8-hour seminar. So you're going to hear some highlights today about approaching these type of claims. And the first segment that we're going to cover is time, because what the legislature has done, and this is true all across the country, is for every claim, there's a time period that the claim has to be pursued within. And as lawyers, the first thing we have to do to really cover you and cover us is remind you of some of the key points as it relates to time periods. So I'm going to have my partner, Salvador Scro, spend a little time on new construction as it relates to condominiums. What are the time periods? If you just come through transition or you're about to come through transition in your condo, Sal, highlight for us the time periods that we need to be apprised of and concerned with.
Hey, good morning, everyone. Good to see some of you and some familiar faces. Nice to have you join us. So there's two time period categories that you need to be concerned with. One is the warranty period, and the other is the statute of limitations. So this is for new condominiums. We probably have tuning in here both board members, unit owners, association managers. So what that means is each of you either have different interests or you may be called upon to respond to various inquiries about warranties for defects. So let's deal with first the statutory warranties, both for common and non-common element defects. So the statute that addresses this for the condominiums is Florida Statute 718.203. That addresses these statutory warranties. Subsection 1 addresses warranties the developer is required to provide. Basically, that means for the unit owner, there's warranties for the unit, and there's, which is in subsection 1A of the statute. If you have that, we can get it to you. The personal property conveyed with the unit is the other warranty that is provided. So for the association, which is all owners, so the first one I talked about was just for the unit owners. There are specific warranties just for the unit owners. For the association, which is all of the owners, there's some personal property for use of owners, and then there's what we primarily find that the warranty deals with is a warranty for roof, structural, electrical, mechanical, plumbing, and then there's a term in there that's other improvements, and that's subsection 1E and C. So for the developer, they offer these warranties 3 years from certificate of occupancy or 1 year from turnover, transition of control from the developer to the unit owners, so whichever is the latest. But in any event, not more than 5 years. So what this means is with warranties, that's when you need to discover the problems. So that's why we always say it's important to do some investigations. This warranty from the developer is a warranty of fitness and merchantability for the purposes or uses intended. It's a pretty broad warranty. It means that what you have should be fit and marketable for the purpose that they constructed it. So for the unit owners, for each unit, there's a 3-year commencing with completion of the building, and typically that's the certificate of occupancy. And then as to the personal property for each unit, that commences with the date. It's the same period that the manufacturer would have provided for that personal property, and that again commences with the date of closing of the purchase or the date of possession, whichever is earlier. And then there's also all other personal property for use of the unit owners. That is what is provided, same as what the manufacturer would provide. What we primarily see and what we deal with is what the association has as a warranty for its common and limited common elements. And that's subsection 1E. which states as to the roof and structural components of a building or other improvements, and as to mechanical, electrical, plumbing, serving the improvements of a building. So that, again, as I stated, was 3 years. There's also a warranty that the general contractor provides and the subcontractors and suppliers provide. And that the difference between the fitness and merchantability statute that the developer provides, this is a fitness as to the work performed and materials supplied. So whatever work they do should be fit, whatever materials they provide should be fit for the purposes that they've supplied them. And that is 3 years from the date of completion of the construction of the building. And then there's also 1 year after completion as to warranty for all other improvements and materials. And subsection 3 of that 718-203 provides for what the completion of the building is. That's the definition for that. So what you need to do is discover within that period of time. So the rule of thumb is 3 years from certificate of occupancy or 1 year from turnover, whichever is latest, but not to exceed 5 years. So make sure you do your investigation during that time. That's to find the problem.
But Sal, that's the developer, Sal.
That's for the developer.
Right. So if a group comes through transition and it's at the time of transition, it's 2.5 years after certificate of occupancy. You can't wait the year. You need to do the discovery within that 6 months so that you preserve the warranty against the general contractor.
That right, with regard to the general contractor, yes.
Yeah. Okay.
So,
what about 718-124? How does that factor in?
718-124. That, and I was going to get to that, and that's 718-124. The statute of limitations for any actions which a condominium association or a cooperative association may have does not begin to run until the unit owners have elected a majority of the members of the board. And that basically means until transition of control to the unit owners from the developer, that's when the statute of limitations will begin to run. Now, initially, it's important to know that the statute of limitations for associations to address defective conditions of common or limited common elements, not the statute of limitations for the owners of those of you listening and concerned with HOAs. We'll talk about that later. But that does not begin to run until the association has been transferred to the owners. So don't confuse a unit owner's statute of limitations with the association's beginning to run of statute of limitations. Section 95.11(3)(c) provides for the 4-year statute of limitations, and this has to do with construction-related matters. Without reading the entire statute, it deals with design, planning, or construction of an improvement to real property. That's 4 years from actual possession, the date of actual possession of the owner, the certificate of occupancy, and then it also states or abandonment of construction or completion of the contract if it deals with the architect or design professional, whichever date is latest. So, however, if there's a latent defect, you get 4 years from the time you discover the defect or when you should have discovered the defect. So the rule of thumb there is 4 years from discovery, or 4 years from completion or 4 years from discovery if it's a latent defect. In any event, there's a statute of repose within that statute, which is 10 years. So if possession is obtained, then from that 10 years, whatever the date of commencement, you have no more than 10 years. So it's important for any of these associations that are under 10 years old and that have not done a thorough investigation, you should really consider thinking about doing that because there is a time period where that statute of repose, it cuts off any right to commence an action.
All right, the summary with my partner's very thorough discussion of time periods relative to condos is if you're about to go through transition or you've just gone through transition, call us up to at least ask the question of, are we under any time pressure to investigate? We generally advise most condo groups to get the engineering report within the first year under either case, but you may be in a situation, depending on the certificate of occupancy date, where really moving forward with the investigation, maybe sometimes within a couple of months of transition, is really important. So contact us about that. So John Lamole,
You have a question?
let's deal with transition of homeowners associations. What time periods do we got to be concerned about?
Okay, good. Alan, I'm glad you gave me this one because this is a little bit easier than Sal's task. Because for homeowners associations, there's no statutory warranties. The legislature has not provided a framework like it has done for condos, which creates certain statutory warranty obligations by the developer and the contractors. So with a homeowners association, you're really tied, your main time limits are going to be the statute of limitations, which is the same as for condominiums, 4 years. So for any kind of construction issue, you have 4 years, or the association has 4 years to bring a claim in court with regard to that defect. And that date is tied to, as Sal said, it's the same, it's discovery of a defect. Discovery of a defect is a kind of a thorny issue sometimes. What type of a defect is it? Is it a patent defect or is it a latent defect? And that's not always a clear thing. I'm going to give you an example just so we can have a little fun here and get everybody to participate. I'm going to share a picture on my screen and I hope it comes up for everybody. Can you all see that wall? Shake your heads because I know you're on, a lot of you are on mute. All right, Alan's telling me he can see it. Well, imagine you're in this, this is your association and this is your perimeter security wall, and you've noticed that you've got this cracking involved in your wall. The developer, if you are going to bring a claim for that defect against them, you can bet that they're going to say that's a patent defect. And so you should take a look at something like that and say, man, we've got a problem. We better do something about it. We better do something about it within 4 years. That doesn't always happen. And sometimes you have an association which doesn't really realize the context or the parameters of the problem. And I'll tell you that, that in this case, what this turned out to be was really more of a latent defect, or at least we argued that it was a latent defect because it wasn't just merely cracking. There was a latent design defect in the wall. The rebar wasn't embedded deep enough, and that's what was creating the cracking. And so you can see by that, that discussion that, the idea of, let me stop sharing this now. The idea of what is a defect and when does your time limit start is a really difficult decision to make sometimes. It's very fact-based. So here's what we always tell our associations that we work with. When you see a defect, don't try to make the decision whether it's a patent defect, a latent defect. Do I have 4 years from today or do I have time to wait? It's best to get an attorney involved right away because that clock may be starting to run. But on the other hand, if it has passed the time, there may be instances where a good attorney can make the argument that, well, we really didn't know that it was a latent defect and we're just finding that out now. So even that crack that may have existed a while ago is something that we can bring a claim on. So it all depends. So if you have a problem, consult with a lawyer and let's evaluate it.
What about the statute of repose, John, as it applies to multifamily buildings that are under the HOA regime?
Correct, right. So the next main time period that homeowners associations need to worry about is the statute of repose. That's a hard stop. The legislature has deemed it appropriate to give developers and contractors and builders a free pass after 10 years. And so if you have a community that's nearing 10 years from completion, it's really important to consult with a lawyer, consult with a construction lawyer, take a look at your community and see if there's any issues which need to be addressed, which may be very costly for the community, because 10 years after completion, you don't have a claim against the developer, the contractor, the builder, you're done. So it's very important that you manage those time periods effectively.
Yeah, and with homeowners associations that have multifamily buildings, so if you're a manager or on the board of an association where there's many buildings and you've just taken over control, you need to really find out what the certificate of occupancy date was for those early buildings. Because developers are making the argument that even though a transition didn't occur until after 10 years after CO, that you're outside the period for those early buildings. So that has to be looked at very carefully. Let me talk about repair contract defaults from a time standpoint. First thing you need to do is review the warranties, because there may be time limitations in the warranties that you have to take fairly quick action on. So the contract needs to be reviewed. Generally, for a defect or a default in a repair project, major repair project, you have 4 years to file suit if that's the way it's going to go. There is the statute of repose also is in play. All right, so the main issue on time periods, it's a fairly convoluted set of principles that you have to understand between warranties and statute of limitations and statute of repose. Probably the best lesson is, give us a call. And just so you know how we work, if any manager or any board member calls us and says, look, here's our situation, here's our dates, we will be happy to confer at no charge and just let you know what time periods may be implicated. All right, so let's get into topic 2, which is choosing the right expert team. Why don't you take that through us? Why is that important? And how would we go about that?
Well, I touched upon this in the last Zoom little seminar we had, and this one is very important to me because we deal with these experts from the beginning of the case to the end of the case. They're the ones that are able to tell us, is there a problem? And what's the extent of the problem? What's the proper protocol for repair of the problem? What's the value of the problem? And do we have enough evidence to prove the problem is something that we work with them through. So I've said this before, and you may have heard it, but it'd be very nice if every building came with a check engine light or a check building light. They don't. And even if it came on, what does it mean? So looks can be deceiving. And I know that a savvy developer who's looking to sell their units, they're going to make the buildings and the units look as nice as they can be. So how does a condominium owner association know, or a homeowner association for that matter, know if there are any defects in the construction? Especially the construction of the common elements and limited common elements that they're responsible for. So the simple answer that works for us is you ask, do we have these problems? And who to ask is the most important question. So the best way for the association to find these answers is to ask a qualified forensic engineer. Selecting the best engineer is not easy. In our opinion, it should not be based solely upon the lowest bidder. And in our opinion, it's also not a good idea for the association board to take on the selection process on its own. So the first person to ask is an experienced construction defect attorney, who they would recommend as the engineer to take on the investigation of the common elements of the property. So why? What do we look for in an expert? So we typically can identify the engineer who we believe, based on our experience with the various engineers that we've dealt with over the years, would best serve the association to first investigate the type of construction. Is it a roof of stucco, windows, roads, drainage issues? What is it? Identify the defects and any code violations in the construction, and prepare a detailed written report, not only with relevant photos of the defective conditions, but also that they can serve as an expert witness, so that in the report they set forth what they investigated, what they found, what violations there are, and the photos to support it. So you also want an expert who can communicate clearly, simple terms, be interesting. No one wants to sit through a boring recitation of barely understandable technical information. And you probably don't want to listen to me saying this either, but it does get somewhat boring. So you want an expert who's able to provide you with not only the facts and why these are problems, but to tell you what caused them and how to repair them. So there's many qualified engineers out there. There's a lot of qualified engineers, but the forensic engineer is a different breed. They're one that are rare to find that can handle all these things. And I know that sometimes associations select an engineer, it doesn't work out. It's tough to change horses in the middle of the race. It makes it difficult because now you might have conflicting opinions. You have the opposition that's going to say, well, you're just shopping for somebody to support the position you want. So you want to make sure you get the right person from the beginning. So the best engineer, in our opinion, is one that does not qualify his or her answers, so they don't offend who they believe might be their next client, or who's afraid to take a clear position on their findings of the defective condition and the appropriate repair. So some engineers represent developers, and then if they come to represent the association, they're doing an investigation. Are they going to say something that affects their ability to get a job from the developer the next time? So you want somebody who's going to be straight with you and point the finger at who's liable for the problems. The wrong engineer is usually a case killer and a waste of association money. So you do not want that.
John, do you want to chime in on subject of expert?
Yeah, sure. Look, folks, if you have a claim against the developer or the builder because there's a significant defect in your community that is going to cost lots of money to fix, and so you want to bring a claim against that person, that developer or builder, besides the choice of the lawyer to represent you, which is maybe the most important choice you can make, the second most important choice you can make is what engineer are you bringing to the table? Because here's the hard reality of it is that if you're in court, the engineer is the one who's making the case for your association. He's the expert. She's the expert. And so matching that person, that expert, with the type of problem that you're dealing with in your community is hugely important. And there are different types of engineers that specialize or focus on different things. I recently dealt with a community that had just gone through turnover and had some site problems. This is a homeowners association, had a number of site issues that they were raising with the developer. That's a very different type of engineer than maybe a different homeowners association that may be dealing with stucco problems and water intrusion in their multifamily buildings. Two very different disciplines. And that's not always apparent. You know, a lot of engineers will say they can do a lot of things, that they, you know, they're jack of all trades in terms of what different types of areas they say they're qualified to evaluate on a forensic basis. But we've got a lot of experience with these engineers. We work with them regularly. We know who specializes in what different areas. So I'm not going to bring an engineer who's really good at looking at roads and drainage and sewers and lift stations to evaluate water intrusion from roofs and building envelope in a multifamily building, or vice versa. I want to bring the expert that's going to bring the best skills, the best qualifications to the table. And because this is a little technical, but I'm just going to throw it out there. Our Supreme Court in Florida has just revised the standard for which experts can be qualified. In other words, the standard by which a judge says, okay, I'm going to allow this expert to testify on this issue and let the jury hear this. And so that expert's qualifications and experience are really important. Get the right engineer for the right to match it to the issues you're facing. And if you have any question about it, call us up, because we know these folks. We work with them regularly, and we'll be able to help you make that choice.
All right, let's get into the guts of claim investigation, preservation of evidence, things that you should be keeping in mind. So
Before we get into that, I've had a couple questions or comments in here that I just wanted to touch on before we leave that subject. One is, can we recommend qualified transition defect engineers? The other, would you recommend we do a reserve study with the same company that does the defect study? Let me address that second one first. Would we recommend we do a reserve study with the same company that does a defect study? Typically not, because the defect study is one that we would usually recommend a qualified forensic engineer. So if you bring in somebody to do a reserve study, they pretty much look at the outside. Forensic engineer looks at things in a peel the onion fashion. A lot of times they'll do what we term, and it sounds pretty rough, but it's a destructive testing. And they peel back the building to see how it was constructed and where the problem is in what they identify. The engineering company that does the defectives or does the reserve study typically just looks at the improvements, figures out what the remaining useful life may be, and what you need to put aside for the reserves. A lot of times those reserve studies are going to conflict with what your actual forensic study does. So it's important that if you're going to do an investigation of the building, look for get some advice from the attorney as to how they would phase this out. I would say have at least a forensic engineer do a walkthrough, see if there's any issues with the building, and if you need to do anything further before you do that reserve study. As far as can we recommend qualified transition defect engineers, Alan, I'll let you address that.
yes, we can, but again, that's a matter of really a private conversation. There's a lot of qualified ones out there. We would want to know what type of issues that you're facing, so we can match the appropriate engineering group with your issue. All right, getting into the guts of claim situation. This applies whether it's a repair job that has gone wrong or a turnover situation. The first key is adequate investigation and testing. In a turnover situation, basically the new board knows very little about what it's taking over, very little about the buildings, and too many times decisions are made based upon a lack of adequate information. So the stage of post turnover is not only to determine whether there's any potential claims that are there, but to support the board in its fiduciary obligation to maintain and repair. It needs to do a proper investigation. And as Sal indicated before, sometimes things are not obvious. If an example of, you may have some stucco cracking, but you don't know why it's cracking. It could be a framing problem. It could be a building movement problem. Or it could be the stucco installation, or it could be a combination of them. You don't know until you do that proper investigation. Also, for proof in the case, you have to have adequate sampling. So, if you have 20 buildings, you can't just look at one building and expect that if you ever get to court on that issue, that a judge is going to accept based upon a sampling method that what was in existence in that one building will apply, especially in many multifamily properties. By the time the developer finishes the project, there may be 3 different framers or 4 different roofers who touch those buildings. And if you're going to hold a particular roofer accountable for the work that they did, you better present proof on the buildings that they did the roofing on. The roofs of the other properties are really going to be irrelevant to them. So Sal, spend a little time on preservation of evidence. What does that mean, and why is it important?
Well, this, a lot of times, the big issue I have with that primarily is if an association has problems and the board or the manager says we need to take care of this, and they go out there and they start doing repairs or start taking things apart, what that happens is there's a destruction of evidence. And John's going to touch on that. But to preserve the evidence is something that when you do obtain samples, they should be stored properly. They should be labeled as to the date and who took them. You know, keep them where they won't be in a high humidity area, so that if they have mold or not, that they don't change the way it was when you took it apart. The other thing that's important too is take photos before, and don't take close-ups right away, because if you take a close-up, we don't know what it is. So start from a wide angle view, get the address, get the wide angle, move in so that whoever takes those photos can identify what they are, and whoever looks at them can go in the sequence and find out, well, this is a photo of this area. So you take a wide angle view and you get it that way. Samples, you should keep those. Minutes and manager reports, be careful about what you say, especially, let's go back to the beginning of this conversation with statute of limitations. If you have minutes or reports and you're identifying, hey, we had a leak in this building, and you don't do anything about it, and 4 years later there's another leak, and now all of a sudden you find out that there's a problem with the windows or the roof or the stucco that's causing this leak, you're going to go back to that report and somebody's going to say, you knew about this 5 years ago and you didn't do anything about it, so your cause of action is gone. So be careful what you say. If you're not sure, ask before you put anything in writing. Temporary repairs also, if you're going to do a temporary repair, for example, if we're in a litigation matter and there's some problems that are affecting the common elements or the unit owners, and you have to make a repair, but it's not going to be a full repair, you want to make sure that that is identified as a temporary repair. You need to be careful as to how you get proposals to do these repairs. If somebody is coming to do what we would consider a temporary repair, and then they're offering you a warranty, how can they warranty something that isn't a complete repair? So you need to be careful about that. And that's why we typically walk through the steps of what to look for, how to phrase it, what it's actually going to do, because you may intend it to be one thing, but the way it's documented turns out to be something else. Also, if you're going to do any type of repairs that require any type of going inside of a unit or any type of percussion on the outside walls that may reverberate into the units, go into the units with the permission of the owners, tell them you want to document some evidence of the condition of the inside, because the lamp that's sitting on the table that they got at Walmart for $20, if it breaks, now all of a sudden it's an heirloom that's worth $50,000 that they can't replace. So you want to make sure you take photos of things and document that.
All right, John, let's talk about notice. Why is that important? And we're talking about notice to opposing parties or the liable parties.
Right. You're most of you on this chat meeting are property managers, board members. Imagine, and I feel for you. You guys have a difficult job sometimes. I mean, imagine you're managing, or you're the board member of a community, a condo that's that's maybe 5 or 6 or 7 years old, and all of a sudden you start to have some problems with your roofs, and you're leaking, and you've got unit owners that are angry because they've got water coming in, and you've got to do something. And so naturally the inclination is I'm going to fix this. I need to take care of this. And who wouldn't do that? You may have a claim, you may not, you just don't know at this point. Here's why it's important. Here's some things that you need to consider when you're faced with that situation. If you do have a claim, every construction claim that you would bring against a developer, a contractor, a builder, an architect to design, the roof system, has got to be preceded by a formal notice, a statutory 558 notice. You got to do that. You got to bring that. And when you do that, you're going to trigger the opportunity for the other side to come in and inspect the conditions that you're saying are problematic. And if you've repaired them already and you've gotten rid of the evidence, so to speak, you can bet that if you do bring a lawsuit against that party, they're going to claim that one of the defenses they're going to raise is spoliation of evidence. Spoliation is basically a legal word for you destroyed the evidence. You didn't preserve it. We can't see it. We have no way of knowing what, of checking whether what you said existed, whether that defect was, was there or not. And if they really press the issue, that can create some problems in proving your case. So at a minimum, if you're faced with that situation, and I get it, you got to make these repairs. Whether you have a claim or not, call us, because at a minimum, and it won't, maybe it doesn't, it won't cost, a tremendous amount of money, but maybe we put the people on notice who should be put on notice, satisfy the 558 obligation, give them the opportunity to come and see the repairs you're making so that they can never come back and say, you didn't preserve evidence if it ends up that you have to bring a claim against that contractor, builder, developer, whoever it is. That's a hugely important thing. And when everything's hitting the fan and you've got to make some, tough choices and you've got people saying, repair this now. Sometimes the best thing to do is go ahead and repair it, but let's make sure we're putting everybody on notice. Give us a call, talk to us. We'll guide you through that process. And, if that's all that needs to be done is, you just put these people on notice and there's really not a defect and whatever it is, you've at least protected yourself. You've preserved a potential claim if you have to make it down the road.
Sal, let's get into the subject of claims analysis. Really focusing on the cost benefit of pursuing a claim, not pursuing a claim. What things do you take in mind in making a cost benefit analysis?
Well, this is the bottom line. This is why you would want us involved at all, is because we're looking to recover for the defective conditions that you have so that you're not paying for correcting these problems. So the first issue would be, what's the size or the quality of the claim? So whether or not to retain a construction defect attorney to handle your claim depends upon a variety of factors, all of which a construction defect attorney can review with you. These factors would include, what's the damage amount? What's the cost to repair or replace the defective conditions? The timing of the claim. Is there a potential loss of a portion of the claim due to the passage of time or the failure to act? So it's very important that when you find symptoms, because symptoms lead to triggering of a statute of limitations beginning to find these problems. So if you see problems, make sure you don't just sit on them. Do something, contact somebody. We would say contact the construction defect attorney to say, here's an issue, how would you recommend going about addressing it? And then the other issue would be, what evidence do you have to support your claim? So all those things reflect upon what the quality of the claim is. The next thing you have to look at would be collectability. So even if it's a great claim, legally speaking, one that's been commenced timely, plenty of supporting evidence, a good value to the claim, still could be a problem. And these issues should be recognized as best as possibly by your construction defect attorney. So a good CD attorney, construction defect attorney, can recognize the hurdles to recovery and find possible other avenues to recover for the claim. For example, a contractor may not be insured or may not be adequately insured. So what other ways can we look to recover? First, we need to look, do they have any assets themselves that would cover it? Are there subcontractors that we can deal with? Also, is the claim such that there was possibly a claim that you can make under your own insurance? Is there something that could fit under a collapse claim if it's that type of a severe damage? And when you think of collapse claims, you don't need to think, oh, my building didn't fall down. there's different types of issues that you can possibly fit under your insurance. So even if the best of claims, the misconception is that if they have insurance, they have to pay. That's not the case. So insurance companies do not cover the defective work of the contractor they insure. It only covers typically for the consequential damages. Sometimes, and in some cases, you'll find that the general contractor's insurance does cover the claims for the defective conditions of its subcontractors. Those are some of the best policies you'll find out there. But those damages that they cover are typically what are called consequential damages. Those are the damages that, as a result of the defective work, it damaged other property. For example, the roofer's work damaged the stucco, the window installation damaged the stucco, something like that, which now the insurance company, it triggers them in, it locks them in, and gives them a reason to at least come to the table and consider settlement. So you have to be aware that of those issues. You also have to be aware that some insurance that applies the cost of the defense to the limits of the policy. So typically you'll find that in a design professional's insurance. If there's an engineer or an architect that has been negligent or has given a defective design, their insurance company may be in the game, but every day that they're paying their defense costs, at some point they say, we're out of money. So you want to look at that in advance so that you're not losing the possibility of recovery. And what's the net that can be expected? This is where, a lot of boards, they want all their money back to recover. And typically that doesn't happen. And a lot of times what I'll talk to our clients about when we're in the middle of settlement negotiations or mediation or something is, you've all seen the show Deal or No Deal, I'm sure. And you don't open any bad cases, and somebody tells that they give you an offer of, you get $350,000, and they say no deal. And why do they do that? That's $350,000 that was offered to you. It's your money. Now, in some cases, we would say, okay, that's not enough. We would recommend you move forward. But in some cases, when it's borderline, you say, okay, you got an offer of $350,000. You get an offer of $1 million. You get an offer of $2 million. Okay. In Deal or No Deal, they say no deal. Why? Because they don't believe it's their money. But if you knocked on that person's door and they had $350,000 in the bank and you said, will you give me $350,000 for your opportunity to maybe collect $1.5 million? I doubt they're going to pay you $350,000. So you need to be aware of that, because at some point, as board members, you're going to need to go back to your owners and explain that you had this offer, you didn't take it. Why is it? Many times, like I said, we will tell you we don't think it's a good enough offer. And that's most of the times. But you need to understand what you can expect. The other thing that you need to take into consideration in settling any claims is what your reserves are. So you put aside reserves for roof, painting, all these other things. The roof was defective. You're suing to collect for the bad roof, but you've already gone through 6 years of this roof or 10 years of this roof, and you've put aside some reserves. So you do have money, but you do need to take that into consideration that you did get some use out of the roof, even though it was defective. You may be applying some of your reserves to that. The goal is that you're not coming out of pocket with anything more than you would have had it been done right. So our goal is to maximize the recovery, limit the risks, and have more than if the association and not to recover at all. Because the next problem is if you don't do that, the alternative is that the owners bear the full burden of the repairs, and you do not want that.
Yeah, I mean, I've been pursuing developers for 42 years, my 42nd year in practice. And if I was asked what I have done during all my career, I have pursued parties and gotten recovery to support repairs that if the pursuit didn't occur, the owners would have had to pay for 100%. So a good result, this needs to be communicated to the owners. If we don't pursue this case, the owners are guaranteed to pay 100% of the cost of repair. If we pursue this case and we can get the opposition parties to pay 60% of the repair cost, That's 60% of the cost that would have been borne by the owners that are now being borne by the responsible parties, which is a realistic result that we've always pursued. So let me just talk about the whole philosophy of claims resolution, because because litigation and court pursuit, they're really looked upon very negatively. So our attitude is we're out to settle every claim. And in fact, in my track record of dealing with condominium and homeowner associations, whether it's a repair issue, whether it's initial turnover claims, more than 95% of the cases that we've been involved in have resolved by way of a negotiated settlement and have not gone to court. I have personally aggressively pursued with my prior firm and this firm these type of claims for 42 years. I've been to trial in major defect cases 6 times in 42 years. And some folks out there may say, well, this guy is a little bit timid about going to trial. Quite the opposite. The reality is most cases have settled because developers do not and contractors do not want to find themselves before a jury made up mostly of folks who live in homeowners associations or otherwise own houses to try to defend their issues before a jury like that. And so the case is settled. Now, why do some cases go to court? A lot of times it's because of what's called third-party practice. If you have a multi-million-dollar claim, the developer is not going to want to bear the burden of that full damage figure. They're going to want their design professionals, their subcontractors, material suppliers sometimes to bear the burden of it. And I'll give an example. This is probably 30 years ago. W.R. Grace, American manufacturer, came up with the idea of manufacturing lightweight fill for insulation for roof decks, above roof decks, over which developers all over Florida installed asphalt roofing. Problem was this lightweight fill product was only tested in Germany under relatively cool conditions, and after it was installed in Florida, the moisture wicked up from the lightweight fill up into the asphalt roofing and destroyed it on roofs all across Florida. Well, the developers and the contractors who did the development and the installation of that were not going to bear the burden of it. So in all of those cases where a developer was pursued for the defective roofs, W.R. Grace was brought in as a third-party defendant. So a lot of times what drives major cases into court is the fact that the developer wants to pass on the liability, and most of the battle that occurs during the process of the case is in this third-party practice. So cases are going to settle, and very rarely within condo and HOA do they get into court. For homeowners associations, when you're talking about infrastructure claims, roadways, perimeter walls, paving issues, retention ponds, and so forth, our experience is because there's usually no third-party practice, most of those developers will settle those claims. And we've been very successful with the major tract developers when those type of issues are uncovered, and I'm including accounting claims, financial claims, of being able to resolve those issues without any type of court proceeding. So we have walked many homeowners associations, including ones that don't have multifamily buildings. We've helped them deal with their retention pond issues, the regulatory issues. And for the most part, what we've ended up with in those situations is being able to reach a negotiated settlement. So let me let me bring this to a conclusion because I know there's a few questions about how we work. First of all, if in any turnover situation, whether you're approaching turnover or after turnover, or in a situation where you're going to undertake a major repair effort, or you have a major repair project that has gone off the rails, as sometimes occurs, we offer at least a 1 hour free consultation. So contact us when you're approaching any of those situations. We'll do in the present day, we'll do a Zoom meeting with the board, or it could be a committee coming through before transition to help orient them as to what's possible. There's a lot of times I'll have somebody send us the contract if it's a repair job before we get onto the meeting with you, to at least know the bare bones of what you've agreed to, so that our input is relevant. Somebody asked a question about our how we charge our fees. Well, we will handle some certain cases on a full contingency basis. Some cases are strictly on an hourly basis. Some cases are partial hourly and partial contingency. But what's the philosophy behind our fee schedule? And the eye that we keep on the ball is what type of financial arrangement is going to result in the greatest net recovery for our client. So if you're an association and you have one of the major tract developers who developed your property and you have $5 million worth of claims, if a law firm wants to come in and say to you, we'll do your $5 million case against Pulte or KB Home or Lennar on a 35% contingency. What basically you're doing is that you're guaranteeing that law firm 35%. I didn't do the addition, but that's over $1.5 million worth of fees. But what if you approach that in a different way? Let's say with a hybrid arrangement, so that the fees ended up being 20% of the total recovery, and the association walked away with an 80% net. So we'll sit down with you and evaluate the situation. But I've been in situations where group says, no, we must have a full contingency, and I said, fine. If you want to guarantee our firm 35% of a $5 million recovery that you're going to get in this case, we'll take that. But really, our attitude is what's going to result in the greatest net for the association. What other question did we have here before we? There's a question of what is a legal hurdle for effective turnover? Does it require agreement by both parties? For both homeowners associations and condo associations, there's a section of the statutes that applies to turnover. Once you hit the thresholds for turnover in the statute, the developer is required to turn it over. If the developer's dragging their feet, you can go to court to actually require turnover, but generally they will comply once they hit those thresholds. So you don't need agreement from the developer. They're generally obliged to do so. There's a question about reserve studies. Is the condo board bound to follow the study or not? The board probably should present a budget that has the reserves that are called for in the study, at which point there would be an owner vote to either waive the reserves in their entirety, or the owners could adopt reserve level less than what's indicated. But although not required, probably the board should follow the reserve study. It's at least coming up with that initial budget, which then by a vote of the owners can be reduced. So we're coming to a close, and I'm going to repeat our commitment. Every question that was sent to us in advance is going to be responded to. Either we're going to answer it or we're going to refer you to somebody who can answer it. So we will do it. There's a question about whether the recording of the meeting will be made available. And I believe Michelle Colburn, our Director of Business Development, has recorded this. It'll probably go on our website as a result. So that's going to be available. And I think I've covered all the items that could be covered. So I want to thank everybody for attending. Michelle, you have anything to add?
Yes, I will email everybody the recording once it gets up and ready. And also our next Smart Boards panel and property managers legal guide will be held on March 4th. And if you have any other questions, please feel free to contact us at any time. We're more than happy to have a conversation with you. And we hope you have a great day and you stay warm.
All right, everybody, thank you. And we'd like to continue this each month. Hopefully you find some of the information that we provided to be valuable. Thank you.
Thank you, everybody.